This is Colin O'Keefe here again for LXBN TV. As we continue our coverage of LegalTech New York 2014, I am joined now by Adam Losey. He is founder and president of IT-Lex. He is also a lawyer with Foley Lardner. Adam, first, as this is of course a legal technology conference, what are the biggest trends or developments that you're seeing in the legal technology space?
Well, I see three things in three different categories. E-discovery, information security and privacy, and depending on how you define it, big data concerns. And on the e-discovery front, on the law side, we're seeing a lot more litigation of spoliation and issues regarding the preservation of evidence. And there's kind of this weird rule in chemistry, Boyle's law, and another law that say when something goes up, the direct proportionality of the converse principle goes down, and there's another one that has them both being congruent. And I say that briefly because I see in huge cases, we have a number of very large cases where you've got two big litigants looking at each other. And Apple v. Samsung is a great example where you've got two giants, and both of them get sanctioned for spoliation. Once they start digging, they find something wrong. And so when you have big cases, you can expect, as a matter of course, for your discovery efforts to come under a microscope. And what's interesting is the converse can be true, especially in labor and employment cases, in that frequently, and certainly many people are very much prejudiced by spoliation and make legitimate issue of it, but sometimes when somebody's claim isn't so great substantively, they realize that perhaps you've done something wrong in preservation, and instead of proving the substantive case, whatever it may be, they just need to prove that you didn't preserve an email that they can then argue would prove their case. So in big cases, we're seeing this a lot. But then the crazy thing is in very small cases, you're seeing a lot of attention paid to it because companies frequently don't want to put a lot of resources into e-discovery and preservation in very small cases. And plaintiffs' lawyers realize that that can be a weak chink in the armor. The legal technology corollary is I'm seeing a lot more attention paid to internal litigation hold management systems. A lot of people do it by spreadsheet or even pen and ink, and there's a lot of error there. Spreadsheet switcheroos happen and people get sanctioned for it. So I see more people entering the market in that, but I think there's actually more competition in litigation hold management, and part of that's made tricky by a lot of clients have very particular requirements where things need to be tailored to them. Plus, in the e-discovery front, I mean, as always, there's just an incredible amount of competition in the marketplace. A lot of vendors out there, and I see this year a lot of vendors very smartly trying to really distinguish themselves from the pack in creative ways.
I see, absolutely. Yeah, the e-discovery space is certainly a very big pack, so it certainly pays to differentiate. Once again, that was Adam Losey of IT-Lex and Foley Lardner. For more of our coverage of LegalTech New York 2014, be sure to visit us at LXBN.com if you're not watching us here already. Thank you for joining me today, Adam.
Thank you for having me.